in the United States and the history of demonetization. Then, while speaking about the Reserve Bank of India being the bulwark of the Indian economy, I've quoted Internet and Mobile Association of India versus RBI, wherein the importance of the bank in the Indian economy. Then I've spoken about the economic and the decisions referred to above or the subject of judicial review of economic policy may be that the scope of interference by a court is limited to instances where the impugned scheme of 3 that the court may not undertake a foray of an economic policy. As such, an analysis is the prerogative of the government in consultation with expert decisions. I shall limit my examination of the matter to such extent as is necessary for the purpose of determining whether the process concluding and allied aspects of the case in this aspect of the matter would not amount to interfering with or sitting in judgment over the merits of the policy of demonetization. There I have made again a table with a view to lend pressed in a tabular form. The parameters for distinction. Then second, when the proposal for demonetization originates from the central government, parameter is role of the bank. The third parameter is extent of demonetization that may be proposed and carried out. Fourth, consideration to carry out demonetization. At 6, applicability of subsection 2 of section 26 of the by the Central Board of the Bank. It is a case. It is not under section 26(2) of the bank of the Act. It is to be by way of a legislation. India in relation to the power of the central government on initiating the process of demonetization for all denomination of banknotes, Syria Council for the petitioners regarding subsection 2. To this end, the following aspects have to be examined. A. Whether demonetization section 26 of the Act. B. Extent of the central government's power to carry out for demonetization can emanate either from the central government or from the central board of the bank. It is, however, designated by the Central Board of the Bank. When the bank recommends demonetization, it is, in my view, made under subsection 2 of section 26 of the Act. The word any in subsection 2 cannot be read to mean arbitrariness or suffer from unguided discretion being given to the central bank of the board of the bank by the central government. Of the Central Board of the Bank by issuance of a gazette notification by the central government. Therefore, in my considered view, the powers of the central government being vast, the same have to be exercised only through a plenary legislation or a legislative process rather than by an executive act by the issuance of a notification in the Gazette of India. It is necessary that the Parliament, which consists of the representatives of the people of this country, discusses the matter and thereafter approves and supports the implementation of the scheme of demonetization. The central government, as already noted, could have several compulsions for initiating demonetization of the banknotes already in circulation in the economy, and it could do so even in the absence of a recommendation as per subsection 2 of section 26 Act of the Central Board of the Bank. On its bank to demonetize the banknotes, the advice or opinion of the central bank, which has to be consulted, may not always be in support of the proposal of the central government, as in the year 1978. The central board may give a negative opinion or a concurring opinion. In either of the situations, the central government may proceed to demonetize the banknotes, but only through a legislative process, either through an ordinance followed by a legislation if the parliament is not in session, or by a plenary legislation before the Parliament, and depending upon the passage of the bill as an act, carry out its proposal of demonetization. Then they have given the reasons for the same, and I have said why it should be through the legislative process. A parliament is often referred to as a nation in miniature. It is the basis for democracy. A parliament provides representation of the people of a country and makes their voices heard. Without a parliament, a democracy cannot thrive. Every democratic country needs a parliament for the smooth conduct of its governance and to give meaning to democracy in the true sense. Parliament, which is the center of our democracy, cannot be left aloof in a matter of such importance. Its views on the subject of demonetization are critical and of utmost importance. Nobody states that the impugned Gazette notification dated 8 November 2016 of the central government was published on the initiation of a proposal of demonetization by the Central Board of the Bank. Proposal for demonetization was initiated by the central government by a letter dated 7 November 2016, addressed by the Finance Secretary to the Governor of the Bank. The central government, having obtained the advice of the bank on its proposal, proceeded to issue the Gazette notification on the very next day, dated 8 November 2016. The same was followed by an ordinance and thereafter an enactment was passed. Then in the incident case, I have said whether the central board of the bank was in a position to visualize the objectives in the incident case. Under what circumstances the central government was consulted by the central board of the bank was consulted by the central government. Then deciphering the plain meaning of subsection 2 of section 26. I said the plain meaning has to be given to this provision. Then I have said that section 3 of the act, which was also in the clause 3 of the ordinance itself, is writ with inherent contradiction because it says notwithstanding anything contained in the Reserve Bank of India Act 1934 or any other law for the time being in force, and then says the 8th November 2016 notification issued under subsection 2 of 26, section 26. Therefore, there is an inherent contradiction there in the provision itself. Then I have gone to the affidavits and record of the case, and the Government of India as well as the Reserve Bank of India, each of them gave 4 documents they have been looked into. And on looking into the records, I find that the use of the words or phrases such as desired by the central government. Government had recommended the withdrawal of legal tender of existing 500 and rupees 1000 notes. Recommendation has been obtained, etc. are self-explanatory. This demonstrates that there was no independent application of mind by the bank. Neither was there any time for the bank to apply its mind in such a serious issue. This observation is being made having regard to the fact that the entire exercise of demonetization of all series of banknotes of rupees 500 and rupees 1000 was carried out in 24 hours. A situation where an independent authority such as the bank, based on its own appreciation of the economic climate of the country, recommends a measure to the central government must be contrasted with another situation where a measure which originates from the central government is simply placed before such independent authority for seeking advice or opinion on such proposed measure. Proposal of the central government on a certain scheme having serious economic ramification has to be placed before the bank to seek its expert opinion as to its viability of such a scheme. The bank as an expert body may render advice on such a proposal and on some occasions may even concur with the same. However, even such concurrence to a proposal originating from the central government is not akin to an original recommendation of the central board of the bank within the meaning of section 26, subsection 2 of the Act. Then I have gone through the affidavits of the Union of India and contrasted it with the affidavits of the bank. On a close reading of the notification dated 8th November 2016, in juxtaposition with the records, the following aspects emerge. One aspect of the matter which emerges with no ambiguity is that the proposal for demonetization originated from the central government by way of its letter addressed to the bank dated 7th November 2016. This aspect forms the central plank of the controversy at hand, that the recommendation did not originate from the bank under subsection 2 of section 26 of the Act, but was obtained from the bank in the form of an opinion on the proposal for demonetization submitted by the central government. Such an opinion could not be considered to be a recommendation as required by the central government in order to proceed under subsection 2 of section 26 of the Act. Even if it is assumed for the sake of argument that the said opinion was in fact a recommendation under subsection 2 of section 26 of the Act, in light of the interpretation given by me herein above to the phrase any series or any denomination,